more on this, let's now speak to legal analyst Clarisa Vermaak. Clarisa, thank you so much for your time and good afternoon to you. So firstly, just talk to us about how you see this matter, going in court, given that the 10 want the interdict to be enforced on an urgent basis until there's an outcome on their review application.
I think the 10 are very much within their right to request that this matter be heard on an urgent basis. The reason for this is the ramification if the interdict is in fact not granted. I'm sure that the court will err on the side of caution in possibly granting the interdict because of the prejudice that will suffer if it's not granted. The implication of that is that the 10 will then, should the interdict not be granted, have to bring in another application if the main case is proven to actually remove the members who's been appointed in their positions in the interim, which would cause a chaos in our legal system and be a chaos for the matter as well. The stance that the Constitutional Court also took in the case involving former President Jacob Zuma is to salvage the integrity of the South African democracy, which I think that the court would be cognizant of in deciding on this urgent application as well.
I want to go back to chaos in the legal system that you speak of. Please, can you elaborate a little bit on that?
Well, the fact of the matter is if the interdict is not granted, members are appointed in what would effectively be the 10's position. To unscramble the hypothetical egg, they would have to bring an application, and provided that their resignation, the signatures has been paused and they are actually reinstated as MPs, they would have to bring an application to remove the members who's been sworn in the interim. And that would obviously be a logistical nightmare. More legal costs would be incurred. The court's time would be used up for this application as well. And it is for that reason that the court will probably err on the side of caution in granting this interdict, given that there is sufficient legal grounds for this application to be brought on an urgent basis.
I just want to also hang on to that urgency matter. I would imagine because of what we're seeing in Parliament happening at the moment with more MKP members being sworn in, therein lies the urgency.
Absolutely, you're 100% correct in stating that. There's actually been active steps taken to sworn in more members, and it's exactly in that aspect that the urgency lies. It's not an anticipated future event that might happen that we're waiting for. It has already happened, and I'm sure the urgency would also be found in this matter when the judge decides the matter.
I know you spoke a little bit about this, but they're arguing, of course, that their expulsion had violated the legal principle of procedural fairness and that, in fact, their resignation letters were forged. Now, how would they go about proving this?
Well, forgery is a common law crime, and unfortunately, no one is exempted from the consequences of that. So the crime itself would have to be proven. They'd have to place documents before the court that proves that they didn't actually sign these resignation letters themselves, that someone did. And on this, I might just turn to the definition of forgery, which is the unlawful and intentional making of a false document to the prejudice of another. If they can prove this, the forgery is found to be there, and then the natural legal ramifications, which includes a criminal law process, would follow that.
And I'm wondering then what the other argument is, in terms of, the court hearing, of course, that former President Jacob Zuma removed the disgruntled MPs because they did not possess the right skills to serve as parliamentarians. I mean, how would that hold up in court, especially if you consider that some of the dismissed members actually returned to their jobs at a swearing-in ceremony for other replacements last week?
And that's definitely an aspect that is under scrutiny in this matter. I might turn to mention that the MK membership oath declaration says that the members vow to be disciplined, loyal and active members of the MK party. If signatures are being forged within the parties, this will certainly bring the party and how disciplined these members are into question, which is something the MK party, as from an internal viewpoint, should be cognizant of.
Clarisa, I'm not sure if, I'm just seeing that there is actually, in fact, an update on the story. I see that the court case actually might be, halted, but I'm not sure to what the merits are. But in the event that it is halted because some of the members are seeing or seeking some point of an agreement, I mean, would that be, enough for this case then to be halted or to actually be removed from the roll?
It's difficult to actually, determine what this agreement entails. Are they talking about a possible settlement agreement that the parties are negotiating in the background, which is very possible? We should remember that if the parties to these proceedings come to a settlement agreement before the judge grants judgment, it can even be after this urgent application has been heard, and they inform the judge of the settlement agreement and move for an order in terms of the settlement agreement, the order which the judge would have made then doesn't even see the light. So the halt and what the agreement might be is for speculation for all of us, but it can definitely happen that a settlement agreement instead of the judge's order is then made an order of court when it comes to this urgent application.
But I guess then that's where we probably have to leave it to just get sense and make sense of why then it was halted and what the agreement exactly is. But Clarisa, thank you so much for your time, a legal analyst there, Clarisa Vermaak, just giving us a sense of what to make of this MK Party court case that's currently in the Western Cape High Court.